Hey everybody, welcome to Thursday night. John Skiba here with the Consumer Warrior YouTube channel. I'm also the founder of the Arizona Consumer Law Group. That's why I've decided to use this virtual background for my Arizona roots here, where I live here in the state of Arizona. And I guess they're over here. People always ask, do they actually have cactus like this? Yes, they do. Yes, we do. They're called saguaro cactuses. And I actually grew up in Utah, and I always thought these kind of cactus were only in like Peanuts cartoons, Snoopy, that kind of thing, but they really exist. They're all over the place. And I actually believe this is here in Arizona, the Phoenix area is really the only place they're found in the world. Someone else can correct me if I'm wrong, but I believe that these are here. And yes, and if you want them in your yard, they're super expensive to buy. Here's one other, this is what you came here for tonight, was a trivia on cactus. So the saguaro cactus, when they grow, they don't sprout the arms that go up until they're at least 75 years old. Someone can fact check me on that, but that's what I've been told. And I've actually looked it up. So it's 75 years old. But anyways, thank you all for being here tonight. We do this each and every Thursday night. If you have a question, and we already have questions on there, go ahead and put them in the channel. If you're on YouTube or in the comment section over on Facebook, I'm happy to put them up on the screen and we can talk to you. So as far as one other thing in the thing there, check out our great sponsors of our show here with Solo Suit. Go ahead and check out over there. They have some cool new settlement tools that you can use to try to resolve this. When it comes to settlement, a lot of people, we talk a lot about different approaches and strategies to defending debt collection lawsuits. I can tell you a lot of times settlement is a good option, and sometimes it's good just to get it done and out of your life and move on. The problem with debt collection lawsuits, particularly when you're representing yourself, is they take over your life. You go to work all day, come home, and you have to deal with that and study and watch YouTube videos, which this is a good thing. This is a good place to spend that time. So to go ahead and check that out. So I wanted to start by talking a little bit about bankruptcy, like I put in the title of the show tonight. Bankruptcy in 2025. We are seeing kind of an uptick in bankruptcies here in Arizona, where I practice. The bankruptcy process. I'm going to give one tip as far as if you're considering bankruptcy, something that can really help your situation out is to get your tax returns filed. Now, I'm not only talking about 2024, but prior years. A lot of people that call me here in my practice in the state of Arizona, they haven't filed tax returns for multiple years. In my office, we typically don't file a bankruptcy case until the tax returns are brought current, meaning that they've actually been filed, not that the taxes are all paid. But that's an important part. It's something the United States Trustee's office has made a real emphasis on, is making sure that you have your tax returns filed. And they actually, even if you file your case and tax returns have not been filed, it's going to be something where they won't close it out. So I would recommend getting that done if you're looking at bankruptcy in the new year. Again, we do free consultations where we'll talk about it. We can actually even start working on it, but we typically don't file it until you get the tax returns submitted to the court. So, okay, let's see here. The couple questions. Roger was here nice early. Let's go over Roger's question. Get up and over it. The problem with these virtual backgrounds is it makes my hair look weird. All right. Roger says, hi, John. In your experience, what percentage of people who apply for Chapter 7 bankruptcy get approved for it? What are some of the common reasons you've seen that would cause people to be disqualified from a Chapter 7? Good question. When it comes to bankruptcy, Chapter 7 bankruptcy, you have to qualify. You have to pass what's called the means test. The means test is based on, essentially what they do is they look at the number of people in your household, and then they look at your income. And if you are at or below the average income for a family of your size in your state, then you can qualify to file Chapter 7. However, if you're above it, you may end up having to file a Chapter 13 bankruptcy. So Chapter 7, for example, let me give you some, and this varies from state to state because they do base it upon numbers from your community. So right now, and this changes throughout the year, but right now in Arizona, an individual in Arizona can file a Chapter 7 bankruptcy if they make about $68,000 a year or less, or about $5,700 a month. And this is gross. So before any type of taxes are taken out of it, that's the cutoff. If you're a little bit above it, you still can qualify for a Chapter 7. We can deduct things like your taxes, car payments, house payments, medical bills, those kind of things. But it's likely something, if you're too far above it, if it's 68,000 for an individual, but you're making 90, you're probably going to end up in a Chapter 13 bankruptcy. Now, it does go up depending on the number of people who are in your household. For example, a household of 2 is 83,000 a year is the cutoff. Household of 3, 99,000. Household of 4, 110,000. All the way up to, let's say you have a household of 8, it's $149,000 a year, or about $12,000 a month. And we count the total number of people who live in the home, regardless of whether you're related, whether you're married, not married, and all that kind of stuff. We look at the total number of people in your household. Now, it is important to know, if you're married, whether both of you are filing the bankruptcy or not, we're going to have to include both of your income in that calculation. So if you're legally married, we have to count both spouses. And the period of time that we look as far as income goes, we look back over the last 6 months prior to the filing of the bankruptcy. We take an average, not counting the month that you file in, just to make it a little more confusing. So, for example, I'm recording this here at the end of January. For the people who are looking to file bankruptcy, we go from December 31st back 6 months, so back to June 1st. When we roll over into February on Saturday, then we're going to go from January 31st and go back 6 months from there. So take a look at that. That's just something to know as far as that's the biggest reason people don't qualify. The only other reason you wouldn't qualify is if you have filed a prior bankruptcy case. You can file a Chapter 7 bankruptcy and receive a discharge once every 8 years. And if you filed a prior bankruptcy and got a discharge and it has not been 8 years, then it's something where you wouldn't be able to file a Chapter 7. If you filed a prior Chapter 7 and it was not discharged, it got dismissed for some reason, then you could be eligible for a Chapter 7. All right, let's see here. Ransom says, question, if someone is filing a Chapter 7, but they are close on the means test, is it true that trustees will accept charitable contributions for up to 15% of gross income? Will they ask for documentation? Ransom, this is a great question. And this is actually one I'm surprised I haven't discussed before. Yes, one of the deductions you can make is charitable contributions. And it's up to 15% of your gross income. For people who tithe to churches, that counts. If you give 15% of your income to the Red Cross, that counts. The only thing is that you have to be able to show that you've had a pattern of contributing. As one bankruptcy trustee told me, there's no getting real religious the day before you file kind of thing. We've got to be able to show some kind of contributions to churches. And, sometimes it can even just be a letter. I know some people that have donated consistently, like to their local church, but they're not providing like a statement or something. It's something you could go get a letter if it was necessary. Or if you're doing it through like a bank account, if it was a check or something like that, that kind of documentation would be fine. So that's a good question. And that's a good one. If it's something where you're consistently contributing to a charitable cause, you can deduct that. And that may be the difference between qualifying and not qualifying. All right. Johnny from Mass says, if the only source of income is Social Security, can investment gains on the money be garnished by the judgment creditor? That is a good question. So I take it, so you're getting Social Security, you're investing the Social Security money, and can the gains be garnished by a judgment creditor? Well, the first thing that comes to mind when I hear that question is how the mechanism or the procedure for the creditor to actually know about it and where those funds are held. If it's something where, because Social Security, whether it's in a bank account or whatever it is, just your run-of-the-mill creditor cannot garnish that. They can try to, but you can raise an objection because it's exempt and they wouldn't be able to take it. So the question is, though, if those investment gains are put into some separate account, I would argue, if I were a creditor, that they can be garnished because they are no longer in the nature of Social Security from the government. I don't know that off the top of my head. That's a really good question. That's a research question that lawyers would need to spend some time getting into, because there may be some cases specifically on it. my guess is that the gains from the investments, from the Social Security investments, would not be exempt. All right, Ransom had another question regarding Chapter 13. What if a retired person files and that person has not filed taxes in many years? I know that Chapter 13 trustees usually require debtors to be current on taxes. Along those same lines, what if a retired Chapter 13 debtor files a declaration saying that he hasn't filed since he retired? So, good question. And I kind of talked about this at the very beginning about the tax returns. If you're not required to file, let's say like our prior Johnny from Mass, only income is Social Security. If your income is only Social Security and you're not required to file, legally required to file a tax return, or if your income is below the limit required to file a tax return, I believe that's about $14,000 a year this year, then no, you don't have to file. And sometimes we even just have the client fill out an affidavit that states, hey, I was not required to file due to the income levels. So Eric says, if you file an emergency filing for Chapter 7, does it allow you time to get the paperwork together? Yes. And I can tell you that well, I wouldn't call it an emergency. We file our bankruptcy cases in 2 stages pretty much all the time. So the initial filing is the voluntary petition. It's about a 5-page document, name, address, Social Security number, that kind of stuff on it. File it with the court, and that all of a sudden, what that does is that triggers the automatic stay. So that's the order from the court that stops all collections. It'll stop foreclosures, lawsuits, all that kind of stuff right from the very beginning. And then you have 14 days to submit the remainder of the documents, which are called the schedules and statements. That's the rest of the 100-page packet you got to submit. So you have a little bit of time. You have 2 weeks to get that submitted. And sometimes they'll even extend that out if you file a motion, but not usually. So, all right, let's see here. Okay, going back to Johnny says it's in Bitcoin. Bitcoin, they're going to go after that 100%. I can tell you, it used to be, I would get a lot of questions of people like, well, how are they going to know if you have Bitcoin? One, you're required to disclose it. It's a felony to not disclose an asset. So I always tell people you don't want to step in front of that danger at all. So you need to disclose it. 2, if you look at the large online like wallets, Coinbase, Robinhood, all that, you can actually find on their websites, links for bankruptcy trustees to be able to fill out a form, submit it, and they will disclose what your cryptocurrency is. So that's something to look at. All right. Says, hi, John. How are you? Doing good. Glad I'm on tonight as well. I got hit with a bank garnishment, but was not served a writ of execution. Thinking about filing bankruptcy. Oh, I'm sorry to hear that. The garnishment, particularly, the bank garnishments are rough because you don't get notice until your account's already frozen. You just wake up and your account's frozen. And then they usually give you a period of time to object. Like in Arizona, you have 10 days to raise the objection to any type of garnishment that they're doing here. If you feel that the money in the account is exempt or there's some other reason that you should be able to do that. So if you were to file for bankruptcy, and I should tell you this, at least in Arizona, and I know in a lot of other jurisdictions, they freeze the funds with the garnishment. But then what it will do is they don't actually transfer them to the creditor until you've had your time period to raise your objection. If you file a bankruptcy during that time period, even just the voluntary petition, like I was talking about with those emergency filings, that will give the automatic stay in place. And then the bank is required to release the freeze and the hold on those funds and not transfer anything to the creditor. But it has to happen pretty quick. So that's something to be aware of. Also, you have to be aware of in your state, I saw there you're in Pennsylvania, you're going to have to look, and this is where you should talk to an attorney in Pennsylvania and see what the exemptions are. Some states have an amount, like in Arizona, we have a bank account exemption, protects up to $5,000 per person. As far as in a married couple, it's $10,000. So $5,000 is exempt. And in some other states, it's like a wild card exemption that can protect money in the account. So, all right. Roger says, you mentioned before that junk debt buyers pay about 4 cents on the dollar for the debt they purchase. One of them has told me that they won't settle for less than 80% of the balance. How do I get them to settle with me for closer to what they actually pay for the debt than the 80% balance they're quoting me? So they will, they pay 4 cents on the dollar. Some pay 10 cents on the dollar. Some pay, I saw an article where some of them pay less than a penny on the dollar for debts that are outside the statute of limitations. If you really want to do a deep dive into junk debt buying, there's a book out there called Bad Paper. It is really fascinating. I mean, it's almost like a organized crime type book when you read it, as far as this debt that's bought and sold, that kind of thing. So I would, as far as how do you get them to come down, you're never going to get them to come down to the amount of, 4 cents on the dollar. Almost never are they going to come down that low. And if they can show that they legitimately purchased it, regardless of what they paid for it, they're able to pursue the full balance. And so that's the, kind of the risk when it comes to litigation. And I talked about settlement up at the beginning. That's one of the benefits of trying to get the case settled if you feel like the case is not strong, if your defenses are not strong. But as far as what you can do to get them to come down, two bits of advice I give you. One is you need to be willing to walk away. If they're coming to you with an 80% balance and you can't do that, or you're unwilling to do that, say, fine, I'm done then. If you're not going to come down, we can just kind of play this out and see how it goes. If they, the second thing you can do is provide them with information that helps them to make a decision as far as why they should come down further. For example, hardship information. If your income is Social Security, if your income is only Social Security, they can't garnish that. And so you tell them that, and in their mind, they're like, okay, this is going to be a case that's going to be very difficult for us to collect on. You can provide them information if there's health issues, if there's been family issues, within reason as far as providing details, but just providing something where that, particularly if you're dealing with like a debt collector or an attorney, where they can then take that information to their client and say, look, they've had this family tragedy, or they just lost their house, or they have one thing, like I have a client right now that has like 12 different accounts that they're in collections, they're being sued on. And so I'm going to the other creditors and I'm using that to play off each other, saying, look, they've got 12 different accounts. You can take this money and settle it now, or we're going to go to the other 11 and see what they're being willing to take. So really help them to sell that to their client, help them to be able to provide a reason or a basis that they can articulate as far as why a lesser amount should be accepted. And then I think you'll be okay there. All right. Derek says Midland wants to dismiss without prejudice after a motion to dismiss and arbitrate. I countered with a motion to dismiss with prejudice. They say they want to dismiss anyway. Just want to say thank you. Awesome. That's what we want. We want the dismissal with prejudice. What's funny is sometimes they'll fight on the dismissal without prejudice or with prejudice. And that just means, by the way, for those who are new to that, with prejudice, if it's dismissed with prejudice, it means they cannot file it again ever. They're done. Without prejudice, it means it can be refiled. When it's dismissed without prejudice, I know they just want to keep that option there. I rarely see them actually refile it again. So something that, just to keep in mind. So, all right, let's see here. This one's okay. Shanita says, if I file Chapter 13, how long will it take me to recover? So Chapter 13, the difference between the two, Chapter 13 is anywhere from a 3 to 5 year process where you have to pay back some of the debts. Chapter 7 is about a 4 to 5 month process. There's no repayment required. Chapter 7 will stay on your credit report for 10 years. It shows up in the public records section on your credit report. There's a little area there. That's where it'll show up. It stays there for 10 years. Chapter 13 stays on your credit report for 7 years. Now, as far as like the recovering from it, interestingly, to me, I've seen my Chapter 7 clients recover more quickly. Usually you can buy homes again, regular mortgages around 2 years, FHA, VA. You can do 2 years, you can get a loan. Some lenders are 3, but the score actually rebounds pretty quickly. Usually within about 12 months, it's come up over 100 points. Chapter 13 can be a little bit more tricky, even though it seems kind of backwards because you're actually repaying some of the debts. It's only on the credit report for 7 years. The issue that some lenders have is that you have an active bankruptcy case for 3 to 5 years. And so because of that, sometimes lending can be a little more difficult. That being said, I have had banks, like just last year, I had 2 of my Chapter 13 clients who were able to get a mortgage loan while they were in Chapter 13. And what those lenders looked at is the monthly payments that you're required to make to the bankruptcy trustee. In a Chapter 13, they looked to make sure that for 12 months straight that they made those on time. And that made a big difference there. So, all right, let's see here. All right, Nick, we're going to dive through all your questions here. It says, my wife and I are 50-50 business owners. We had a huge setback last year, out of our control, and we're currently suing for damages from our own supplier. But in the meantime, our relationship with creditors got ruined. My wife had $95,000 of debt that got settled by American Express for a small percentage. They negotiated with me through me on her debt, but for me, they're suing me and won't settle for anything close to the number they negotiate on her accounts. Plus, they want the money very quickly. Any suggestions? We're talking $150,000 balance. They were saying 60% within 30 days or 75% over 24 months are my only options. Okay, so they are suing you. So there is a lawsuit. I'm going to tell you, American Express, they are, one, they don't sell their debt. Two, they're fairly aggressive. They will usually file suit within 12 months of you stopping making payments on it. The one kind of little silver lining that I have seen is that if you continue to press them on this, I have had large balances like that. I had one $200,000 Amex card with a client, and we were able to get a payment plan on a reduced balance over 8 years with no interest. And so what I did, and sometimes it helps actually if the lawsuit's been filed. And the reason why I say that is because, one, you're dealing usually with an attorney, and they tend to have a little more flexibility in trying to get the case resolved. Two, you can enter into what's called a stipulated judgment. And this is basically a settlement where you agree to terms. You say, okay, there's 150 grand owed. I agree to pay back 100,000 of that. I'm going to pay it back over 72 months. I'm going to pay it, installments on each of as we go. And I'm going to back it with a stipulated judgment. I'm going to stipulate to a judgment, but this judgment is going to have terms. It's going to have some terms in there that say, look, here's what we're going to do. 100,000 paid out over 72 months or whatever it is you negotiate, no interest. And it's going to have in there something called a covenant not to execute. They're not going to be able to pursue you as long as you're making those payments. But there's usually also a term in there that says if you stop making the payments, not only do they have their judgment for the 100 grand, but they get the whole 150 grand plus attorney's fees. So it gives the creditor a sense of security in the fact that they don't have to try to resue you. They're not going to run into statute of limitations problems. And then if you make the payments on time, then you're good to go and you can be done with it. Once you pay it off, they'll file a satisfaction of judgment and you'll be done. You got a discounted payment as far as the total amount owed over a longer period of time. The key to making those successful, there's two terms I always put in there. One is that you need to make it so that it's no interest. I have seen people who negotiate these things. They get 4 years into it and they owe more than what they did because the interest is accruing. So make it no interest, and then make sure you put a grace period in there. If you say, hey, I'm going to pay you on the first of each month, but the first falls on a Sunday and then you don't get paid till Tuesday. And I always say put like a 7 to 14 day grace period in there, whatever they'll agree to, just to give yourself a little bit of time, just in case something happens there. All right. I'm a cookie says, I'm actually going to court tomorrow. I have the money to pay the loan total balance I owe. Is there any way to argue against the $4,000 they're charging for attorney's fees? So you can reach out. Here's what I would do. I would reach out tonight, if it's, via email, first thing in the morning, whatever it is, and say, I'll pay the total amount owed. Including interest, whatever it is that they're seeking. And the reason is if they say, no, we're going to trial, you go in, the judge says, okay, you owe the total amount. And then if they ask for attorney's fees, that's usually when I raise the objection and say, hey, judge, I offered to pay the full balance here. They just wanted to go to trial to get attorney's fees. Most courts will not look kindly on that and will, if anything, reduce it or sometimes just bar it completely. So make sure you go in. I would put something in writing, an email whatever, and come prepared to make the full payment. And find out what it is. Bring a cashier's check, whatever it is, so that you can try to get that squared away. Or you can even ask for the judge for a continuance and say, you know what, you're willing to pay the balance right now. Maybe do that even on the record and see if the judge will go ahead and push it off. So, all right, let's see here. Do I think their lawyers are being truthful when they say they won't go below 60%? I think they're being truthful that maybe their client says that they don't want to go below 60%, but they will. I always say, rule of thumb, the creditor wants money. If you're offering money, there's got to be some middle ground to be able to make this work out. So, oh, you know what, Nick? I actually saw you said you called my office today. Didn't get a call back. Huge fan. You know what? We will give you a call. I apologize about that. We actually have new staff starting Monday because we've had a ton of calls. And so that's my fault. We'll get that squared away. Give us a call back. Shoot me an email. We'll make sure we get it taken care of. So, all right. I wanted to go over just a couple questions or comments that were put in the comments section. This person said, a previous employer told me that a junk debt collector had won a judgment against me without notifying me that there was a court case, was even granted a wage garnishment. This happens all the time. We see this frequently. As you know, I've talked about it forever. For 12 years on this channel, 95% of debt collection lawsuits end in a default judgment because they served the wrong place. People are avoiding service. People just are served and don't respond. But because of that, we see this a lot where people don't respond, or they serve inappropriately or in violation of the rules, and a judgment gets entered. You may be able to unwind that. You have to find out how it is that they got you served. Go get the affidavit of service or certificate of service. Look and see how it is that they actually got you served. And if they didn't do that appropriately, even at an advanced stage, then even with a wage garnishment pending, you may be able to unwind it. Alternatively, if service was good, a bankruptcy, like we said, will stop the wage garnishment immediately. This person said, I have a question for you. Can the bankruptcy trustee come after me after the bankruptcy is discharged? So the bankruptcy trustees, they work for the Department of Justice, the United States Trustees Program. Their job in a Chapter 7 case is to review the paperwork, make sure it's been all submitted, and then they look to see if there's any assets that can be sold for the benefit of creditors. If there is, they will do that, and then they'll distribute the funds to your creditors. So the question here, can the trustee still come after me after the bankruptcy is discharged? The answer to that is yes. But there's kind of a finer point to that. There's two steps to closing the bankruptcy. There is the discharge order, which in a Chapter 7 takes about 4 months. The discharge order is the order signed by your judge, says you don't owe these debts anymore and you're done. However, the case is not administratively closed out by the clerk of the court until the trustee files all of their paperwork saying, all right, we're done. There's nothing to distribute here, or no, I'm still working on this. I've had Chapter 7 cases stay open for years. Super rare. I don't want to scare anyone away from Chapter 7 because of that, but it's usually more complex cases where there's lots of assets that they're trying to go after. And so, yes, they can come after you after it's discharged. We routinely tell our clients, hey, the discharge is in, but if they need additional information or documents, you need to provide it. Usually the only things that they're going after is like if you get an inheritance within 180 days, within 6 months of filing bankruptcy, you have to disclose that. In Arizona, they go after tax refunds sometimes, but typically they have some pressure on them as well to try to get this thing resolved and get the case closed out. So, all right, this question actually goes along well with some of the questions we got asked throughout the show tonight. If the only income is Social Security, I understand debt collectors cannot touch that. Any point in doing anything? I get this question frequently here in my practice in Arizona. My income is exempt. I'm getting Social Security. I'm getting VA disability. Types of income that cannot be touched. Should I just ignore the lawsuit and blow this off, or should I look at bankruptcy, or should I look at fighting the lawsuit? In certain situations, you can just do nothing. With the understanding, if the creditor gets a judgment against you, in most states, that judgment is good for a certain period of time, and then it can be renewed for a certain period of time. So, for example, in Arizona, civil judgments are good for 10 years, and then they can be renewed every 10 years for the rest of your life. And so because of that, I always say, if you are judgment proof, if your income is such that they can't touch it, or you don't have any assets, will that be true 10 years from now, 20 years from now, 30 years from now? If your situation is going to change, then you may want to look at dealing with it now, so that this $5,000 judgment that they have doesn't turn into a $35,000 judgment 20 years from now with all the interest that's accrued on it. Also, you want to look at if you own real estate. It may be something they can't garnish your pay, but maybe you own a home and they could sue you, get a judgment, record it, then it would act as a lien against your home. That could be an issue. So if there's other assets other than your income that they could try to go after, those are the kinds of things to think about. So hopefully that is helpful. And if there's any other questions, I think we'll wrap this up for tonight. But if there's any other questions, put them in the channel there, and I'm happy to come back. Like I said, maybe we'll put them up on the screen next time and address them then. Go ahead and check out Solo Suit. And if you haven't subscribed yet, please do so. It really helps me out, and I really appreciate it. If you're in Arizona and you need some help, I offer free consultations. My information's scrolling along the bottom there. I'd be happy to help out. And with that, we'll catch you next week.